site because of the existing boundary screening around the site. So it just gives you context of now and previously later on in the year. And again, this is just coming through the access track, and again, the site is within here, and again, it establishes how well the existing screening is around the site. So this is the application proposal. So you've got the existing caravan here, you've got the outbuildings, you've got the trailer area here. So this is the lawful pitch that was approved under the previous consent. That's decision notice 15506338. So that is a lawful Gypsy and Traveller site pitch, and this is the proposal for this caravan here. So again, it's set away from that boundary, so in terms of screening, it's particularly well screened from the existing site, and hence, in terms of the officer report and visual impact, is considered to have no additional impact in landscape terms, given the lawfulness of the existing site. That is a very significant consideration that I would ask members to bear in mind in terms of the location of that site. This is the next door application, and I'll go through to that later, where you've got a proposal to put those here. I previously referred to members some distances in terms of the distances you've got on the site, in terms of site licence requirements, and again, if there are questions on that later, I'll deal with those as they arise. So the key issues are set out in the report. The site has been established as a Gypsy and Traveller site under planning approval, as I previously referred to, 15506338, for one mobile and one static. This accepted the Gypsy status of the applicant, and the current application is for his son. This was accepted as the site was considered appropriate in landscape terms and caused little harm to the countryside, given the well-established screening of the site. Added to this is the allocation in the emerging local plan, GT17, for 4 permanent pitches. These 2 applications would then accord with the emerging local plan, and that, again, as I previously said, is a significant material consideration. The inspector considered the allocations and on the Gypsy and Traveller topic paper at the emerging local plan, and in his interim findings didn't raise particular issues or didn't note those issues arising out of the G&T. So what in effect that said is that said with our allocations in the emerging local plan, which seeks to approximately deliver 40 units, that the council would meet its need over the planned period. So this site contributes to that need issue and establishes our 5.6-year supply of G&T sites as we currently stand. So on that basis, the application is recommended for approval, and I have nothing further to add, Mr. Chairman. Thank you.
Thank you for that. I'd like to call on Councillor Goddard, Hunton Parish Council.
I'm going to treat both these applications together, if that's okay, on the same statement. Hunton Parish Council objects to these applications because the maximum allocation of 4 pitches in the local plan is based on an incorrect measurement of the applicant's land. Key to our objection is that the size of this site is only half an acre. It was originally measured at a full acre because the access track was included, which the applicants do not own. They have a right of access only, so it should definitely not be included in any calculation of the maximum number of pitches. I've gone through the local plan and measured the size of every Gypsy and Traveller site within policy GT1. All sites adhere to a maximum ratio of 4 pitches per acre. So at half an acre, the Chancellor's site should therefore have a maximum pitch number in the local plan of 2 and not 4. This ratio has been applied consistently by planning officers, and a level of 4 was only set for the Chancellors because of this measuring error. Members have been sent a map via email that shows the total size of this site to be 2,090 square metres, or half an acre. And officers have been sent land registry evidence to prove this. Sarah Ocamp owns the land to the west of the footpath under title deed K854108. So the chances we know is definitely half an acre. Currently, permission has been granted for 2 pitches, i.e. 2 statics and 2 tourers. The actual number on the site is 4 statics and 4 tourers, with a further application for one of the pitches to be divided to allow a 5th static. This may be what Mr Bayliss has referred to, the one that's been refused. This would amount to highly dense overcrowding on only half an acre. The screening of this site is very poor, and this will always be a problem because there is a hill to the north, so it will always be overlooked. This is contrary to point 8.2 in the planning report, which states, and I quote, "The landscape in the vicinity of the application site is relatively flat agricultural land." In point of fact, the Ordnance Survey shows that if one proceeds 400 metres to the north, you would be 30 metres higher than the chances. And Lycos Lane itself is 4 metres higher than the site. So the land in the vicinity is definitely not flat. We believe that the disposal of wastewater poses a potential health risk. There are 2 cesspits on the chances, which are likely to be inadequate for an increased number of caravans on the site. The chances is higher than the nearby culvert and the adjacent King George V playing field. So in the event of an overflow or leak, there is a high risk of polluting the watercourse and the playing field, from which the chances is very visible. We are aware of GT1's target of 187 gypsy and traveller pitches, and we're also aware that pressure to provide these pitches comes from central government. The development plan was sent to the Secretary of State last year, and the report places emphasis on the undoubted weight held by this plan and its policies. But I would assume that the Secretary of State would expect that basic calculations of pitches per acre were based on accurate measurement of the correct piece of land, in order that planning policy would be implemented consistently across the borough. This site will always be overlooked to the north, but most importantly, the chances is half an acre and should only have a maximum of 2 pitches in the local plan. I would urge members not to vote this through on the nod merely because it's in the local plan, but I would ask that you refuse these applications because the planning report has just got this wrong. With 4 pitches, the chances site does not meet policy. Thank you.
Thank you, Councillor Goddard. I don't think there are any ward members, are there, here? So, Councillor Harwood, then, first.
Thank you, Chairman. I think this is... Right, thank you, Chairman. I think this and the following one are 2 of the most straightforward applications that we've had. I mean, these are allocated sites. In terms of the density issue, I would advise members to go down to Water Lane if they want to see the density. That's a Maidstone Borough Council-owned site, of course. And I do worry a little bit about some of the health and safety issues with the proximity. This site, you see the belt of trees out in the wood, but it is a very, very well-screened site all year round, not just in the summer. There are no planning grounds, I think, to have an issue with this one. The points that were made around wastewater and so on, that will all be dealt with by the application. So therefore, I'll just move that we grant permission as per the papers, if I may. Thank you.
Do I have a seconder for that? Councillor English. Councillor Prendergast, you like the floor?
I'm not seconding, I'd like to...
Yes, yes. Yeah, that's what I asked you. I have your seconding, yeah. Yeah, do you want to comment? Sorry, I do apologise, Clive, I didn't mean to...
I hear what I just want a clarification as to... I think I do agree with Councillor Harwood that this is an extremely acceptable site in general and it is generally well screened. I just want to check something though. In terms of the alleged issue with the area of the site, I mean it is important to get these things right nevertheless. So just check whether there is any impact from that, but I have to say that from observation of other sites, not all recently approved, admittedly, but from some other sites in the borough, there is a considerably higher density than that. So I would have thought it was acceptable. But I do think it's, as the parish council have raised that, but we probably should give them an answer on that point.
And I do agree. And before I give the floor to Councillor Prendergast, I'll ask Mr Bailey to come back on that.
I mean, as members will be aware, the sites are regulated under the Caravan Sites and Controlled Development Act 1960, where you get a caravan site licence. And in terms of that site licence, that sets out certain parameters and distance. The speaker earlier said there was almost some kind of forensic analysis of site allocations for G&T sites. That is not so in terms of the local plan, as Councillor English has advised that there are different sizes of all the different sizes within the G&T sites within the borough, and the local plan does not do a forensic analysis of the size, nor should it so, because that issue is controlled by a site licence in terms of safety precautions, in terms of distances from boundaries and distances for fire safety issues. So that issue is dealt with under separate legislation, which is dealt with by our environmental health team. So, and within that, licence granting sets all the parameters and sets all the provisions in terms of distances from relevant boundaries and buildings. So, hopefully that addresses the issue. I'm not going to say in terms of I forensically analysed the actual site area for this particular application and whether it conforms to the site licence requirements, because that is dealt with under a separate piece of legislation, and that wouldn't be something that members could either require an applicant to go down that route in terms of site lights, because it's dealt with separately. So there is separate legislation, separate enforcement powers that cover those particular matters.
Thank you, Mr Bailey. Councillor Prendergast.
Thank you. I want to ask the same question, really. I will elaborate on it as Councillor English. The application site. Are we absolutely confident that it's 0.4 of a hectare? Because I've gone back and looked at Regulation 18 submissions from the Parish Council and other people, and this has been raised time and time again, going back a couple of years, and I can't see any response to it anywhere. I know you, Mr Bailey, you've just said that the Inspector has published his interim report and has made no mention of our Gypsy and Traveller allocations. But that doesn't mean that he's not going to. That is just an interim report. And I don't, we haven't seen his final thing, his final report. So I'm not sure that we can give any weight to that unless he has specifically put in writing somewhere or said to you, I've covered everything I'm going to cover. The other thing that's worrying me a little is no one's made any mention of the impacts on the playing field adjacent to this, the George V playing fields, which I think includes a village hall as well, widely used. What is going to be the, how is this development going to affect the amenity of the playing field and the users of the playing field? I think it's, it's an important consideration. And the other thing that I want to know is, I know we say the Gypsy the traveller status has been established because it's an established traveller site, but what about the nomadic habit as detailed in the PPTS of August 2015? I can't see anything here. I'm not used to, when we see applications of this nature, I'm used to some reference to that in the committee report, and there isn't one here. So if it is much smaller and it's not as detailed in this committee report here, and we need to be 100, I need to be 100% confident. If things are not correct here, then yes, I know that this counts towards our allocation, our 5-year supply. But we've got 187 pitches to find during the plan period. I believe we are already at 101. There are a further 40 that we've identified in the local plan, and there is an allowance for windfall sites. So really, we are exceeding our targets at the moment. So we should confidently meet our 187 assessed number. So I'd just like to know that we are doing the right thing here, and this is as it is, and everything has been looked at properly, starting with the size and the nomadic status and the impacts on the playing fields next door. Thank you.
I'm going to take it in the order that I come to my memory first, if you don't mind. In terms of take a bit of an issue with saying we are exceeding our supply, because unless you could find me the evidence where it says that, I've got in front of me the topic paper that was published to the Inspector's interim findings, and nowhere does it say we're meeting our need. We're actually undershooting our need, and we've had to justify how we're doing that to the planning inspector. So I just think that needs to be very clearly understood. We are not meeting our need. And what we've justified to the planning inspector is that we've come up with a justification for our shortfall in supply due to the turnover from established permanent sites. So that's how we've justified. The inspector seems to have accepted that principle, because the issue we went out to exhaustive call for sites on G&T issues. So it is not right to say we're meeting our need, but I think the inspector has generally accepted that we're going as much as we possibly can to meet that need. This site is an identified supply site to meet the need that we're meeting the shortfall on. So I think that needs to be borne in mind very carefully. The reference to the inspector not referring to it, the whole point of an interim report is to guide the local authority so its direction and course of direction is correct when the full findings. So I agree with you saying that just because he doesn't reference it doesn't mean he's not going to address it in his report. He will address it in the report, but it's a clear indication that he doesn't have a concern regarding our G&T traveller allocation and how we've dealt with it. Otherwise, he would have dealt with it up front and we would have had to deal with it. So that hopefully deals with that point. With regard to the playing fields, I would just refer you to paragraph 8.1 to 8.3, which assesses the visual impact. Now, that is what the officer is meant to do, and draw the attention to the visual impact in terms of what the visual impacts are. I would just refer you to this photograph, and I accept I saying it's coming from Lughorse Lane. It shows the background screening of the site. This is the unlawful caravan on the site that's been recently refused. And then I just go back to the screening around the site around here and the screening as the backdrop around it. So, to my mind, the site is very well screened. In terms of, I'm not saying that I've assessed it from every single vantage point that you'd be able to see it. I think I would be lying if I said that. But I consider the site to be extremely well screened, and the officer has addressed that, to my mind, in the assessment of his report. With regard to nomadic lifestyle, I would refer you to paragraph 714, the gypsy status, which does set out nomadic. Nomadic means that the G&T individual has to undertake a nomadic lifestyle, which means for work purposes, travelling for work purposes. That was established quite recently in April 2016 by the grant of the permanent consent, and your officer's view is this application is for his son, and that continues to be so. The case law dictates that the officer doesn't have to quite clearly set out every element in terms of how they comply with that definition, and that, as you will know, is a clear case law parameter, but the officer's mind is clearly drawn to that fact that he complies with the definition. Hopefully that addresses all the points you raised. Unless I've missed something out, I'll happily address that later.
Thank you, Mr. Bailey. I've got three more speakers, then we'll probably go for the vote. Councillor Mumford, please.
This might be a technical question. It's really for the planners, and it's to satisfy my mind on this application and future ones. What we've got is, and to satisfy Hunton's objections to it, and that is the nomadic status. Now, I've read this report, and I understand most of it, and that the applicant, because of the previous application, the status has already been proven. And he got planning application for his mobile home. And now the family need more, and I know that the definition includes his family. But one would consider, and I'm probably making an assumption here, for the son to need his own mobile, then he is an adult, and surely at that point we should be assessing the son and not the father. It's just a technical point, but I'd like the planner to answer me on that, because what we've done, we've assessed the father, and the assumption that I'm making, I know it's a leap, that the son is now an adult, needs his own caravan, and it's the son we should be applying the status to. I don't know.
Do you want to take that?
It is well-established fact that in terms of the gypsy culture, that in terms of the head of the household establishes, and in terms of you get offspring and you get sons and daughters, and it is an established fact that you would look at the, dare I say it, the main income earner in terms of that family who would seek to comply with the definition. Now, notwithstanding that issue, the officer has considered the gypsy status of the son and has confirmed that they comply with the definitions, because quite clearly the same condition applies, as you'll set out in the rest of the report, in terms of the conditions that they comply with the definition as set out in the PPTS. So in terms of the officer's view is conclusive that the son complies with the definition, but I'm just going back to you to the culture in terms of the head of the household. It is an established fact, and that has been confirmed by opinions that we have had informally with council on numerous discussions we've had.
Thank you, Mr. Bailey. Are you okay with that? Councillor English.
Yes, I mean, Mr Bailey's made it extremely clear that the main point at issue from the Parish Council is out with planning control, because that will be covered by the caravan licensing legislation. And if there is an issue, then it would be picked up at that point. So clearly, leaving that aside, which, as I say, is out with planning control, in all other respects, this is not just an acceptable, but a very acceptable application, and there are absolutely no planning grounds for refusing it. And to be honest, whatever the level of supply we had in the local plan regarding G&T traveller provision, we would have to assess the application, like all applications, on its merits. And frankly, the demerits of it are non-existent. And therefore, it will be extremely difficult, whatever the level of G&T provision, to actually refuse this application.
Thank you, Councillor. Councillor Borden.
Thank you, Mr Chairman. As some of you know, in some of my spare time, I'm a football referee. One of the advantages of being a football referee is you get to visit a lot of village halls dotted around the place. And I've been down to Hunton once or twice before, and until I actually got the papers for last week's meeting, I had no idea that this site was there at all, unless it bordered the playing field. So, as Councillor, you said, it's extremely well screened. The only questions were the one raised by the parish. That's been covered by the officers, so I think we really should proceed with this.
Thank you, Councillor Borden. Well, I see no other speakers, so I'm going to put it straight. I think we have a proposer, which is Councillor Harwood. We had a seconder, which is Councillor English, and I'm going to put this to the vote to approve. 1, 2, 3, 4, 5, 6, 7, 8. Okay, to refuse? 1. And abstain? 3, 4. We got the maths right, haven't we? So the application is approved. Say with conditions. Okay, the final application tonight is, which is obviously related with 16/505/965. Again, the same address, Chances, Locos Lane. I'll hand over to whoever's presenting this.
You've seen the photographs previously. Yes. This application site is the next door site to this site, so it's accessed down through the red line boundary here, and you'll see this is the existing, from the aerial photograph, this is the existing caravan, static caravan on site, and the proposals relate to an additional caravan on here. Again, as I said, the same principal issues apply. I won't go through the photographs again. The site is considered to be particularly well screened. This site, the officer, you'll note, has suggested an additional condition regarding landscaping to supplement and infill that existing landscaping issue. The boundary treatment, again, members please disregard the unlawful caravan that's on site that has been refused. Again, in those photographs, has no bearing. And again, I think just showing the application site, the site is well screened from the immediate locality, and the application is recommended for approval. I've nothing further to add. Thank you, Mr. Chairman.
Thank you, Mr. Bailey. Councillor Harwood.
Thank you, Chairman. In light of our decision on the last application, it would be perverse to make any alternative decision on this one, because we're even getting the applicants to gap up the hedge. So I'll move that we grant permission as per the papers. Thank you.
Councillor Clark, are you seconding that? Thank you. I'm going to put it straight to the vote, actually. Who's in favour?
1, 2, 3, 4, 5, 6, 7, 8.
Against?
1. Abstentions? 2.
Abstentions? No, 3. I abstained last time. Yeah.
Approved with conditions.
Yeah. It's approved with conditions. And members, I think that completes our work tonight, and thank you all very much. Thank you. And thank you, officers, as well.